Our commentator is one of those proverbial folks who needs no introduction. It is Nadine Strossen, professor of law at New York Law School and president of the ACLU for the last 15 years. I can't tell you.
16. Who's counting? I'm really honored to play a minor role in this major conference, and I would also like to thank Suzanne and Mark and everybody else who participated in organizing it, including my other New York Law School colleague, in addition to Mark, Tanina Rothstein. I thought the most useful comments that I could provide on this panel's theme would draw from my experience as a human rights activist, especially with the ACLU. Of course, the ACLU never asks for any personal information about its members or leaders, such as religious or ethnic background. What a treasure trove that would be for demographic and sociological researchers. However, through my countless personal interactions with countless ACLU members and leaders all over the country for 16 years now, it has been my strong impression that Jews and Jewish lawyers in particular are disproportionately overrepresented, and that especially dominant are secular or Reform Jews, which is certainly consistent with the observations of both Willie Forbeth and Ann Southworth. That unorthodox religious orientation of civil liberties lawyers was the butt of a New Yorker cartoon several years ago. It showed Moses in front of Mount Sinai bearing the two tablets. Moses is displaying the tablets to a man who is pulling a wagon, and on the wagon is a golden calf on which is emblazoned 4 letters, ACLU. That ancient ACLUer is scratching his chin skeptically as he contemplates the tablets, and he says to Moses, "The 10 recommendations? I guess I can live with that." The many Jewish lawyers who have handled many ACLU cases include both of the distinguished lawyers that David Langham just discussed, Arthur Knoy and William Kunstler. And here I have to interject a personal acknowledgement of a particular contribution they both made, which greatly helped me, as well as the ACLU and also my other institutional home, New York Law School. When I first became ACLU president, it was very hard to handle all of those new responsibilities along with my prior significant commitments as a law professor. So who should volunteer to help out by teaching one of my New York Law School courses? None other than the dream team of both William Kunstler and Arthur Knoy. Right before this panel, I did have the opportunity to meet Karen Kunstler, Bill's daughter, and she told me that she audited the whole course. It earned rave reviews, not only from Karen, but also from everybody else who was lucky enough to take that course. Beyond Messrs. Knoy and Kunstler, the Jewish lawyers who have been extremely active ACLU advocates and leaders also include 2 of the Jewish justices who have served on the United States Supreme Court. Felix Frankfurter, who was one of the ACLU's founders and a very prominent active ACLU leader until his Supreme Court appointment, and also Ruth Bader Ginsburg, who was one of the ACLU's general counsel and the founding director of the ACLU's Women's Rights Project. The impression that Jewish lawyers are disproportionately represented in the ACLU is widely shared among the ACLU's detractors, as well as our supporters. I still recall my horror the first time I heard my organization branded with a particular anti-Semitic epithet by a hostile talk radio host who was interviewing me shortly after I became president. On air, he introduced me as the head of the ACLU. And since then, I have regularly heard the ACLU smeared, not only with that particular anti-Semitic slur, but also many others. Now, in fairness, I should note that eerily similar verbal attacks regularly come from certain Jewish individuals and organizations, such as the Jewish Defense Organization. David's chuckling here empathetically. These Jewish critics harshly attacked the ACLU's neutral defense of civil liberties, even for anti-Semites, anti-Zionists, and others whose ideas they consider counter to Jewish interests. Just in the past few weeks, for example, I've been called a self-hating Jew, a familiar term that I often hear. This was by someone who teaches at Columbia University and lambasts the ACLU's defense of First Amendment freedoms for certain controversial, outspoken pro-Palestinian members of Columbia's Middle Eastern Studies Department. Along with other critics in that vein, he told me that it is shameful for an organization with such a large Jewish leadership and membership to fail to single out the Jewish people for special protection by tailoring our civil liberties agenda accordingly. And of course, we defend freedom of speech for all of these critics. I hope that's clear. In the context of this conference, I'm mentioning these incidents only to underscore the common themes that unite many of our otherwise very diverse critics coming from very diverse perspectives. What is common for present purposes is they all assume that the ACLU is dominated by Jewish members and leaders. In that same vein, I fundraising letters for many so-called religious right groups that refer to the ACLU. You didn't say what it actually does stand for, Laura, but they say it stands for the Anti-Christian Litigation Union. To be sure, I understand that this epithet is intended to convey disagreement with the ACLU's stances concerning the appropriate relationship between religion and government, and I, of course, realize that reasonable people can certainly disagree with those stances without being anti-Semitic. After all, the swing vote on the Supreme Court to uphold a government-sponsored Ten Commandments display last year, contrary to the ACLU's position, was cast by none other than Stephen Breyer, who is himself a Jew. Nonetheless, for too many significant proponents of government-sponsored religion, the civil libertarian or separationist stance is demonized as being not only specifically anti-Christian, but also associated with Jewishness. For example, in a Los Angeles Times interview not very long ago, a director of the Christian Coalition made this link explicitly. Indeed, he expressly singled out Jewish lawyers in particular, tying directly to the focus of this conference. To quote him, the Jewish element in the ACLU is trying to drive Christianity out of public places because the ACLU is made up of a tremendous amount of Jewish attorneys, close quote. In fact, as I'm sure you all know, the separationist position is strongly supported by many Christian denominations as well as other religious groups. However, the ACLU itself, as well as Jewish organizations, have historically been concerned that this position could be seen as anti-Christian and pro-Jewish. I learned of these historic concerns from Samuel Walker's History of the ACLU, which was published by Oxford University Press in 1990. Let me share with you his discussion of two early Supreme Court decisions involving challenges to government-sponsored religion. Zorek versus Clausen in 1952, in which the court rejected our challenge to release time programs under which public schools released students from their academic classes so they could take religion classes taught by clergy members in the school building. And the second case I'm talking about is Engel versus Vitale in 1962, in which the court struck down the New York Regent's prayer, purportedly non-denominational, as if such a thing would exist, read aloud by teachers in public school classrooms throughout the state. In Walker's book, he explains that both the ACLU and the Jewish groups with which we were working on these cases, the American Jewish Committee, the American Jewish Congress, and the Anti-Defamation Leagues, all of these groups, he says, were acutely sensitive to the then prevalent charges that the separationist position was anti-Christian. And of special pertinence for this conference, Walker notes the impact that that concern had on the involvement of Jewish lawyers in the cases, or more specifically, their non-involvement. In his words, the American Jewish Committee insisted on a non-Jewish plaintiff and non-Jewish attorney in the New York released time case. But many people probably assumed the Jewishness of both anyway, plaintiff Tessim Zorak and attorney Kenneth Greenewalt. The ACLU shared these worries. For the Engel School Prayer case, the New York Civil Liberties Union insisted on non-Jews to serve as both the plaintiff and the lead attorney. The NYCLU therefore assigned the case to the lawyer who was the only member of the NYCLU Lawyers Committee who was not a Jew. The ACLU continues to collaborate closely with many Jewish organizations, including David Saperstein's great group, which is a consistent ally on many key civil liberties issues through both the lobbying and the litigating strategies that David will describe. To again underscore a point that echoes some of Willie's and Ann's observations, these Jewish organizations that are ACLU allies and the lawyers within them come predominantly from the Reform or secular portions of the Jewish spectrum. When